Alright guys, it's time for another Maddox versus Dick lawsuit video. A couple people have been asking what's going on with the case, where are we, what's the next step. So right now we're at the same place we were last time. We're waiting for documents to be filed from the remainder of the defendants. That should be coming any day now, really. I believe that we should have documents by the 14th of December. I'm not an expert on New York civil procedure, but from what I can tell, they have approximately 30 days from the date of service. No, they have 30 days from the date of service to file something. Either an answer, some sort of dispositive motion. Dispositive motions are motions to dismiss or motions for summary judgment. Basically anything that gets rid of an entire claim, that's a dispositive motion. So you can file a dispositive motion, an answer document, or from what I can tell in New York, you could file a notice of appearance, which isn't either of those things, and I'm not 100% sure what they are, because we do it different in my state. So that said, the documents from the remaining defendants, other than Patreon and Cope, who are the only people who have filed so far, should be arriving soon. And as they do, we'll go through them. But for now, as I said in the previous video, we're going to go through the causes of action one at a time. Maybe two at a time, depending on how short they are. But this one's going to just be one. We're going straight for the first cause of action. Invasion of privacy and for injunctive relief pursuant to Civil Rights Law 50 and 51. So this, if you're following along in the document, starts between paragraph 116 and 117. As for just briefly going back to what happens next as far as the lawsuit's concerned, yes, the defense team will file their answers and motions, and then it will be up to the judge to determine that. Expect a pretty good delay period as the judge takes time to consider whatever the defense files. I assume they're going to move for things like either dismissal for lack of jurisdiction, dismissal for failure to state a claim, or motion for summary judgment. All of those things, from what I can tell, favor the defense pretty heavily for most of them. Mainly because, as we're going to go through here, there's just not any evidence. And I know I've said this 100 times, and YouTuber Law has said it, and he's doing a great job being more neutral than I am to the situation. He's putting out some solid content. You guys should check him out. But I've said it a bunch before. There just isn't anything there. There just isn't. But let's go through and see what nothing looks like. Because surprisingly, whatever random homeless person drafted this document has made nothing sure look like a lot. So let's go through that and see what happens. So we're on paragraph 117 here. Plaintiffs replete and incorporate by reference every allegation, blah blah blah. So well, let me take a pause from this and talk about Civil Rights Law section 50 and 51. These are two parts of the same thing. 50 is a statement of the actual like cause of action, and then 51 is a statement of the relief that's involved, and what the cause of action looks like. So section 50 is the right of privacy, and I'll read this one. 51's longer, so I won't. I'll summarize it. But section 50 of the New York McKinney Civil Rights Law is a person, firm, or corporation that uses for advertising purposes or for the purposes of trade the name, portrait, or picture of any living person without having first obtained the written consent of such person, or if a minor, of his or her parent or guardian, is guilty of a misdemeanor. And apparently New York is a gender binary state, and they are hateful and should be stricken from the map. Whatever. Section 51 is different. It just describes the actions and remedies that are available. If someone brings this, they can get injunctive relief, they can get damages, they can get attorney's fees. All that's in Section 51. It doesn't give us any additional insight on the actual cause of action under Section 50, what a right of privacy is, or anything like that. And that's really the question, because the terms of this seem pretty straightforward, right? Person, firm, or corporation uses for advertising purposes or the purposes of trade the name, picture, portrait of any living person without their consent is guilty of a misdemeanor. That is a straightforward thing. But as with all legal things, straightforward things aren't so straightforward. We have to know what advertising purposes and the purposes of trade actually fall into. Because if you can curtail free speech just by calling something an advertising purpose or a purpose of trade, then there is no free speech. So the courts have to be very careful with how they handle this stuff. And the reason they have to be careful in handling it is because if the court in New York is not careful in handling it, it gets kicked up to the Supreme Court of the U.S., and there's a potential that they'll come in and undo the civil rights law of New York based on it violating the Constitution. So we don't want to do that, and it has not been done to that extent. And but there's some really interesting decisions that have happened that help us find exactly where this stuff is. So as we go through the suit here, and I apologize for jumping around, but as we go through the suit, I'll explain those and we'll bring in the cases, because that's what you do in a court case, and that's probably what whoever drafted this lawsuit should have done, but they didn't. Because they're not a lawyer. I don't think. So, paragraph 118. The defendants here, Herrera, Kokonos, Burt, Foundation Digital, Bozer, and Baker. Sure. Defendants use plaintiff's name, photograph, picture, portrait, and or likeness without their written consent within the state of New York for purposes of advertising or trade. Where? That's a good question. Where is a very good question. So if we go to earlier in the complaint, the facts section, and style points for drafting a complaint, you should reference the specific factual allegations you make at the beginning in your causes of action or in your request for relief. You should be referencing what facts violate what law and how they do it. You have to make like a little analysis sort of thing, not just state it, because that helps the judge understand where you're coming from. Otherwise, the judge has to look at all of this stuff. And mind you, this is the first cause of action comes 28 pages in. So there have been 27 pages of facts that a judge is supposed to remember as he looks at these causes of action, and he has to find specific instances. So he's either got to go back and forth, or more likely his clerk, right? The judge is not going to be doing this as much as the clerk is, because judges are busy. And that's clerks' jobs. The clerk is going to have to go back and forth from paragraph 118 all the way back to 33, which is the first allegation of a misappropriation of an image or likeness. And he's going to have to just go back or remember that and try and put that together. But he's not going to know how the plaintiff is reasoning through the application of this thing. And if he doesn't see a logical connection, you're in big trouble. You gotta make an argument. So they say they use a name, picture, portraits, and or likeness without written consent of plaintiffs. So the first example of this is paragraph 33. Below is an example of defendant Herrera's ruthlessness and his misappropriation of plaintiff Jane Doe's image and likeness for his own financial and perverse gain. Now, this is him replying to a tweet which someone else uses the Jane Doe's stage name, which is Metal Jess, and her Twitter handle, they actually just posted her a picture of her Twitter profile showing that they were blocked, right? So that's all that happened here. Defendant Dick didn't actually use the image or likeness for any financial or perverse gain. He didn't use the likeness at all. In fact, in his reply tweet, he doesn't at her. He doesn't use her Twitter handle. He doesn't use her name. She's referred to as she. That is not the use of a likeness or image in an advertisement. That's not even the use of a likeness or an image. That's what I'm getting at here. So then we go through further, and then the next allegation we have is paragraph 37. Defendants have used contests have also had contests to stalk and harass plaintiffs, which, he doesn't allege that this is a breach of the civil rights law for an advertising purpose, but it's one of the closer claims because it involves a billboard, which are traditionally advertising purposes. But it says, biggest problem in the universe, available at biggest.thedickshow.com. That's what's on the proposed billboard in California that never actually occurred, right? This is a computer-generated image. But that's what's on there, and that doesn't use any image or likeness or trade name or anything like that of either defendant. So the next one, defendants Herrera and Kokonos have bought multiple targeted advertising campaigns on Reddit and Facebook targeting plaintiffs. For instance, as recently as September 5th, 2017, Herrera bought a targeted advertisement on Facebook targeting plaintiffs and their fans directly, suggesting that plaintiffs' followers should unsubscribe from his podcast. Except if you read the actual advertisement, there is no mention of either plaintiff. The plaintiff's names, image, likenesses are not in it. So even if we argue that a Facebook ad targeting the plaintiff's fans constitutes advertisement within the state of New York, their likenesses and names aren't used. Now, what he did do was he specifically, apparently, purchased the ad or pushed the ad towards fans of Maddox. However, in the advertisement itself, the defendant does not in any way reference the plaintiffs. Likewise, so 40 is likewise defendants created fake advertising campaigns. Again, what's a fake advertising campaign? I don't understand this term. If you are creating a fake advertising campaign, you're presumably not launching it to advertise a product for a business purpose. Like a fake advertising campaign, as far as I could tell, would be like a comedy skit, right? Like you come up with parody ads for products. And these parody ads are based on either some topical news item or popular joke about the company that they're then going for. Philip Morris murdering children since 1951 or something. If you hate cigarettes, I don't know. I don't create fake advertising campaigns. But if it's a fake advertising campaign, it's presumably not an advertisement or for trade purposes because it's fake. It's not actually there to drive business in any sort of way. So I don't know what that means, and it gets annoying reading it all the time. But they also apparently paid for advertisements to circumvent being blocked on plaintiff sites. Process is straightforward, blah, blah, blah. Here, defendant Kokonos explains it himself and how they did it to plaintiff. Okay, this isn't the use of their likeness in any sort of way either. Defendants do this specifically to harass plaintiffs, and they know advertisements circumvent blocks. Defendant Kokonos admits to it in the following post. Again, posting on Reddit, putting Reddit posts about how they do advertisement strategy is not showing the use of a likeness or image in any sort of thing. And I think it... Well, okay, there's only one more paragraph in the fact section to go through, and that's 42. So we'll do that, and then what I'm going to do is I'm going to explain the elements of this cause of action. Because they're not labeled in the lawsuit, and they should be. Because what you want to do is show how they meet each of the elements. Like, this is... You should have paid the lawyer to draft the document instead of just sign the document. That's all I'm saying. Defendant Herrera, this is paragraph 42, is also using a caricature of plaintiff. By the way, a caricature is not an image or likeness that you own at all. Because that's a creative work of someone else parodying you. That's not your image or likeness. Caricature of plaintiff as the devil in his posters and advertisements to promote a live show he purportedly gave on October 13th, 2017, whereby he sold tickets for $20. But listen, those posters and advertisements are for a show in L.A. It's in L.A. We don't have any evidence that this happened in the state of New York. And that's why I want to go through the elements real quick of this claim. So there are two leading cases which discuss the elements of this claim, and I'm only going to read the portion of one of them because they say the same thing. This is Melina versus Phoenix Sound Incorporated. This is kind of an interesting case, but I don't want to get into it too much. Anyway, so the elements, there's 4 elements to the established liability under the civil rights law for use without consent of likeness, name, or voice. Plaintiff must demonstrate each element. First, usage of plaintiff's name, portrait, picture, or voice. The plaintiff has to show that these things happened, like that the use occurred, and so far, none of the evidence does that. 2, it has to occur within the state of New York. Really important, because New York's not going to control the advertisements of something in a different state. In this document, there's no allegation that it occurs in New York. There's simply leave the judge to infer. They say it's within the state of New York. Okay, they say that, but they don't show how or why, or they don't have like a person with a New York location on their Facebook showing that they've gotten an ad like that. And that's iffy. That's an iffy sort of thing, and it'd be ripe for challenge in court. But they don't do anything to show that any of this stuff actually was ever seen in New York. We have no idea if any advertisements that may show a likeness would have been seen in New York. They have to actually show that. You can't just infer that because, well, something was on Twitter and there are lots of people in New York with Twitter, so they saw it. You have to show it. You have to show it. An affidavit from someone who saw it, maybe. Might be hard to get affidavits if you don't have fans. I don't know. 3, for the purposes of advertising or trade. So they have to show, the plaintiff has to show that this is an advertisement or trade. They can't just say it is. They have to demonstrate how. Typically, like you would show an advertisement, a specific advertisement, and say, look, here's an ad. Here's my name and picture and all that stuff. And then, this is an ad. And we're going to dig into that point because that, like, what is an ad or what is a purpose of trade? That's the big question. And of course, without plaintiff's written consent. And this is the only one that Maddox does well, right? He clearly lays out that he has not given written consent to use his likeness or image, and neither has Jane Doe, otherwise known as Metal Jess. I suppose I have doxed her now, even though it's in the lawsuit. Good job, buddy. You didn't block out her name. He is stated, so the defendant's only defense to this element of the crime would be to produce a writing from one of the plaintiffs that allows the use of an image or likeness. Not going to Probably not going to happen because it probably was not ever used with permission. Although it'd be funny if it was, like if there was an old agreement, maybe, that they had from back when they were partners, that they could use each other's images or likenesses. Like if there was some sort of writing there, that would be interesting. I have no idea if that exists. And from what I can tell, it probably doesn't. I don't know if there's a lot of documentation. Because this is two comedians who kind of trusted each other's friendship. And we're going to just do a show together. And none of this stupid stuff was supposed to happen. But those are the 4 elements. Again, real quickly. Usage of the name, portrait, picture, or voice within the state of New York for the purposes of advertising or trade and without consent. You have to show all 4 or you don't have a case. Period. So, paragraph 120. As set forth more fully above, defendant's entire business is based around their harassment campaigns against plaintiffs and creating content around the use of plaintiff's name, photograph, picture, portrait, and or likeness. 1, you haven't demonstrated that. You've alleged that. And 2, you haven't shown any evidence of how this occurs. Plus, creating content around the usage of this stuff is not creating an advertisement and is not for the purposes of trade. And we're going to get to that in just a minute, but bear with me. To solicit patronage by their fans, defendant's most lucrative use of plaintiff's name, photograph, picture, portrait, and or likeness appears to be through defendant's podcast. Cite the podcast episode in which it occurs. Except if it's inside an episode, it becomes harder and harder to define as an advertisement. So cite an ad that does that. On Patreon, wherein defendants solicit fees from their patrons or fans to access their podcast. But do they solicit on Patreon? Because now you're asserting that it's done on Patreon. On the Patreon page for non-patrons, and I'm guessing you could check this out pretty easily. Do they solicit using your likeness? I have no idea. Maybe we should go real quick. This could be bad. This could be bad for Dick Masterson. I'm gonna take him down with my neutrality. So Dick Masterson is creating the Dick Show. So on the front page, we've got the pledges. Now, I'm not going to read all this because that would be really boring. But I'm going to skim it and see if anywhere there's a mention of either plaintiff. Nope. Okay. So that's on the post section. Let's go to the overview. Let me read Dick's message to this is Dick's message to the fans. This is according to Patreon. When you open a Patreon, they tell you to fill out this section, and this is your enticement for fans to support you. So this is the closest thing I could construe as an advertisement on Patreon. I'm going to read it word for word. The world would be a better place if everyone got more dick. You want dick, your friends want dick, your mom definitely wants dick, even though she might not say so because she's classy. Be sure that she does. And that's exactly what you're supporting with this Patreon. Dick for everyone, dick, more dick, and better dick. Penis. Dick is a weekly science and rage-based podcast where everything is a contest and there ams no rules, especially grammar rules. Chock full of dick tips and the answers to questions like, are you a rage and what even is a libertarian? This dick might be a little shorter than what you're used to, but this dick will also be much beefier. Over the years, you've gotten to know me as Dick Masterson, author of Men Are Better Than Women, and devastating dropper of truth bombs, or as Dick Masterson, the, quote, troll, end quote, who shot a red hot chili pepper up Dr. Phil's ass, or as Dick Masterson, the co-host of The Biggest Problem in the Universe, a show that ranted about serious problems like guys asking about your dog and getting pee on your pants. Now, by supporting this Patreon, you get to know me as Dick Masterson, the host of my very own podcast, Dick. By supporting this Patreon, you'll not only get plenty of dick in your ear, but you'll make sure thousands of others get a fat dose of dick in theirs as well, and who doesn't want that? So whip something valuable out of your pants, your credit card, don't be crass, and make the world a better place. Like I said, the world would be better if everyone got more dick. Thanks and GFY, Dick. Whoa! Did you notice that there is not a single mention of any of the plaintiffs, their likenesses, their trades, their podcasts, nothing. Their Facebook pages aren't linked or mentioned. Not a single thing in what Patreon dubs as the ad. Like, that's the entire thing. This is the ad that Patreon encourages you to write to your potential fans. This is how you get them to join. And the most common used word on here is dick. He's advertising himself. He's not advertising anything to do with either plaintiff. So that's a problematic claim. And that's probably why Maddox... No, I shouldn't even say that. I shouldn't say that that's probably why Maddox didn't click it, because I bet Maddox is too stupid to even understand that you have to provide this evidence. Anyway, so if you're arguing that their primary business, their primary source of revenue is Patreon, and saying that they're doing the advertisement on Patreon, and yet you go to Patreon, there's not a single ad, you're really in trouble with this. Okay, which are principally based on using plaintiff's names. They're principally based on using plaintiff's name, although his name isn't mentioned once on the cover, on the splash page for the Patreon. Inner likenesses as punching bags in the basis of their shows and content. It's a science and rage-based podcast. It says right there. There's actually no advertisement. If there's a person unfamiliar with the situation who comes to this page and looks at it, they will say, oh, okay, I'm going to learn about this guy, Dick Masterson. I saw his book on the shelf. I saw him on Dr. Phil. He was kind of crude but hilarious. Let's see what this is all about. That's what's on the Patreon. Maddox isn't on there at all. Neither is Metal Jess. Jane Doe. I'm assuming Jane Doe is Metal Jess and not some mystery woman. Let's see. Likewise, defendant Kokonos' podcast... Oh, so this is just her Patreon amounts, which don't matter. 121. In addition, defendants specifically... In addition, defendants, specifically, use plaintiff's name, photographs, pictures, portraits, and or likeness in advertising and selling albums on iTunes, Google Play, and Amazon. T-shirts on their websites, books, and have created YouTube stations, websites, social media campaigns, and other content, and advertising campaigns around the destructive and perverted use of plaintiffs' names. Where's a picture of a T-shirt? I've never seen a T-shirt with your name on it. Let's see. Let's go to the store. Shop. On the Dick Show. Dick. Everything is a contest with Dick. Escape from Hollywood with Dick. Dick. Hot Goss. Dick. Hot Goss. You want it, you need it, you love it. Dick Show. That is America's Wingman and TDS hoodie and the $20 Million Man sticker. If you'll notice, if you go look on the shop page, thedickshow.com. Don't go to dickshow.com. Don't do that yourself. If you go to thedickshow.com and you look up the shirts, the stickers, the everything, plaintiffs aren't on any of this art. None of it. So that's a problem, right? You can't just state that things are there that aren't there. That's lying. You're lying under oath. This is an affidavit. Further, defendants have gone on tour, okay, in New York. I think they did a New York live show. Why don't you have the New York live show? Creative flyers and other appalling caricatures and advertisements based on using... Then show them. You haven't shown them. As demonstrated above, defendants use plaintiff's name, inner likeness in numerous ways to advertise to solicit. You haven't demonstrated this. And promote their business to tens of thousands of listeners, fans, and consumers on a variety of formats and popular digital platforms. Yeah, you list all this stuff, but you don't actually show where any of this stuff is in violation. And you had the opportunity. Defendants publish and republish plaintiff's name, photograph, and or likeness on multiple formats, including their own promotion and advertisements. Where? Like, and I'm not going to do the work for you. There's, 83 episodes, I think now? 80 episodes? I don't even know. How many episodes are there? 80 main episodes, and there's some bonus episodes. 18 currently. And none of them that are immediately apparent have your picture on them, or likeness, or name on the thumbnail, or anything like that. So I'm not sure how you argue that they did this. I mean, I know how you say that they did this, but you're going to have a tough time making that argument. Defendant's use of plaintiff's name on countless occasions and in numerous formats. Actually, they're pretty countable. They're very countable, because all you have to do is like find them, and then we can count them. Right now, it's 0. Is clearly recognizable likeness of the plaintiff and is readily identifiable by someone familiar with them. Okay, that's not a thing, by the way. If someone is familiar with you and sees your picture, that is not the use of your likeness to someone who is unfamiliar with you. Like, you have to, I'm guessing you're arguing about the caricature. So the caricature is supposed to be a likeness that would bring someone to see this show or entice them to. But a person who doesn't know who you are and just sees the flyer is not going to look at that caricature and say, oh, I want to go because of that background figure. Plus, that flyer was in LA, right? You haven't even alleged that that was in New York. It's demonstrated by the foregoing. Stop saying that. There's a direct and substantial connection between the appearance of plaintiff's name and likeness and the main purpose and the subject of defendant's advertisement. You haven't shown the main purpose of the advertisement to be you at all. It's very easy to show that the main subject of the show is Dick. That's the easiest thing in the world, because it says it 100,000 times and you are mentioned 0. Defendants' actions against plaintiffs grossly invaded their privacy and violated the civil rights statute in egregious and unconscionable ways. Like, what egregious and unconscionable way can you violate someone's privacy? Like, you're not nude. I hope. Dear Lord, that would be horrifying. Ew. Which included publishing plaintiff's private information, phone numbers, and address. They haven't done that. Like, that's something you should definitely have included, not in this section, but you're talking about egregious and unconscionable things. Those don't matter under this statute. And if you were a lawyer, you would better organize your document to handle this. But right now, all you're trying to show are those 4 elements I mentioned. This section should be like 6 paragraphs long at best, because it should show the first element, how you violate it. Second element, how you violate it. Third element, how you violate it. Fourth element, we didn't give consent. Boom, done. That's how you put this in there, and then you have to force them to defend it. But instead, you've got paragraph after paragraph of this screed. Now you're on Foundation Digital. That they encourage and allow defendant Herrera to use their service to store this stuff. That Foundation Digital is not advertising with you ever. Even if we say the other defendants are, which is the farthest leap I can go to, but even if we agree that the other defendants are advertising, Foundation Digital is not advertising with your picture anywhere. Foundation Digital is never mentioned. No one knew. I guess some people who went through and tried to find out more about Dick might have been able to find the name of his company online, but no one who just listens to the content produced by Dick would know who Foundation Digital is. Even after this, he refuses to say the name of his company on his show, even though it's in a public document. Has been discussed on my video, YouTuber Law, and other public things. He refuses to say the name of the company on air. Why is that? Probably because they're not involved. And they're certainly not advertising their SEO marketing with your stupid face on their thing. That's not a thing that's occurring. Their employees have assisted with Herrera's podcasts, and some of its executives have even appeared on the show. What dates? What dates? Because that's in heavy dispute. I'm pretty sure none of the executives have appeared on the show, as far as I know. Whatever. Promoted it on their social media, such as Defenders, Baker, and Bozer. Linking to a podcast is not an advertisement, by the way, because when you're advertising, you're doing it for your own business. Linking to someone else's business is networking. That's not an advertisement or for purposes of trade, unless you show like a contract for them to do so. Defendant Foundation Digital has therefore has used plaintiff's name. Nope, that doesn't work that way. There's no shared liability here. You have to show the liability of the individual named. They don't get this like attachment liability unless they're creating the ads, maybe. And even then, the contract used to create the ads would probably have an indemnification clause in it, which would render them immune to the lawsuit because they're just creating ads at the direction of someone else. That's not even what happened here. Like, there's no evidence that Foundation Digital has advertised for themselves or on behalf of Dick in any sort of way. On its own, Foundation Digital's storage of all the appalling and reprehensible content indicated above is a gross invasion of plaintiff's privacy. Absolutely not. Absolutely not. The statute does not... First of all, you're in New York, buddy. New York doesn't have a common law invasion of privacy. And under common law, you may be close to right. You're not. But you might be at least scratching at the door to the gate that's a mile away from the main house. Like, you might be there under common law stating that they're violating your privacy by having your private information stored on their servers. That's the biggest stretch I can possibly think of. But that's not New York. New York has a specific statute, and they do not recognize any common law about a right to privacy. It's only under the statute. So you can't do this. You can't do an attachment, and you can't say that because they store stuff on their server that they're violating your rights. Doesn't work that way. Plaintiffs' entire lives have been disrupted. That's not in this section. Plaintiff Jane Doe has been diagnosed with depression, anxiety, PTSD. I mean, she lives with you, I think, in a constant state of fear and anxiety. I would be afraid of you, too. You're weird. Plaintiff has lost fans. Like, losing fans isn't an element of an advertisement that's used improperly. Defendant's conduct was appalling, wanton, and unconscionable. This is a statute. There's not like an appalling, wanton, and unconscionable element to this statute. Right? Is there? Let me skim through 51 real quick. Wanton. Nope. Appalling. Nope. Unconscionable. Nope. Reckless. Nope. There's nothing. You're creating things that aren't in the legal standard. Deliberate disregard of rights, safety, welfare, and therefore... this is you not understanding the law. Defendants collectively, nope, that's not a thing. And each of them individually, that would be a thing. By engaging in the aforementioned acts, and or in authorizing and or ratifying such acts, no. Engaged in willful, malicious, intentional, oppressive, and despicable conduct. The adjective like Wheel of Fortune doesn't help you here. None of these things are elements of a violation of privacy. Disregard for the rights and safety and welfare. Rights, safety, and welfare. You're so wrong on what the statute is. It has nothing to do with your safety and welfare. It has everything to do with your ugly mug generating revenue for you or someone else. This is for models and actors and speakers who are desired and podcasters with audiences. If you don't have those things, your health and safety are not contemplated in this statute or in the case law. It's entirely your face's ability to generate money. That's all that matters. And until you show that they're generating money that you should be generating based on your face, you're not winning. So that's the end of the and yeah, my video cut out there, so I recorded for a little while before noticing. So on to the cases, right? And going through the cases is going to show how the New York State applies the law and why this isn't an ad. Okay, why none of this stuff is an ad? Because even though we read the right of privacy, I mentioned there are limits to what is an advertisement, and the court has to define those. Here we go. This is Walter versus NBC Television Network. This is a woman whose picture was mailed in to Jay Leno. So okay, let me just, this is pretty short. Plaintiff commenced this action against her former employer, defendant Dorsal Automotive Group, and defendants NBC Universal and Jay Leno. After Jay Leno displayed her photographs as part of a comedic, quote, headline segment on The Tonight Show, plaintiff asserted causes of action for violations of Civil Rights Law 50 and 51 and intentional infliction of emotional distress. There we go. We agree, so here, skipping ahead. We agree with the NBC defendants that the court erred in denying that part of their motion to dismiss the civil rights law cause of action against them. We therefore modify the order accordingly. Excuse me. Sections 50 and 51 are, quote, to be narrowly construed and strictly limited to non-consensual commercial appropriations of the name, portrait, or picture of a living person. Here, the use of the plaintiff's photograph by the NBC defendants was not strictly limited to a commercial appropriation, and thus the use of the photograph does not fall within the ambit of those sections of the civil rights law. In addition, sections 50 and 51 of the civil rights law do not apply to reports of newsworthy events, and the issue whether an item is newsworthy is a question of law to be determined by the court. Newsworthiness is to be broadly construed and liberally applied. A performance involving comedy and satire may fall within the ambit of the newsworthiness exception, even if the performance is not related to a legitimate news broadcast or event. We conclude that the comedic component of the newsworthiness exception applies here. We've examined the remaining contentions of the plaintiff in support of her civil rights law cause of action against the NBC defendants and conclude they're lacking in merit. Okay, great. Comedy and satire is newsworthy and is an exception to the advertisement. Like, the definition of advertisement under this statute is so flipping narrow that it has to be explicitly and exclusively an ad. Other than that, it doesn't count. You can't just say it might be an ad. Like, it actually has to be a lie if you're saying it is an ad. It has to be that they're lying about it being an ad. Okay, so the next one is Stefano versus News Group, Publications Incorporated. Shout out to my boy Stefano, if you're out there. So this is a little bit longer, so bear with me. The fact that the defendant may have included this item in its column, this is a picture of a person with a jacket on and some information about the jacket, and the jacket is alleged to be an advertisement. The defendant may have included this item in its column solely or primarily to increase the circulation of its magazine and therefore its profits, as the appellate division suggested, does not mean that the defendant has used the plaintiff's picture for trade purposes within the meaning of the statute. So, even if the sole purpose of including the name or likeness without authorization in an article in this case, or a column, this is a column, but a column, an article, a podcast, it doesn't matter what medium we're talking about. In a work, okay, because this case is from 1984. So even though they may use something that looks just like an ad, like this is a jacket with information about where you can buy it and how much it costs, right? That appears in a column just because, and even if the sole intent of including it is to increase the profit of the publication, That doesn't actually trigger for trade purposes within the meaning of the statute. It has to be an ad, not incidental to something else, not part of the greater work of the podcast. It has to be an ad, an advertisement, not we advertised for our show, like, and you happen to be a portion of that show or a focus of that show. That's not an ad using your image or likeness. That's more of a newsworthiness type thing. So let's see. Indeed, most publications seek to increase their circulation and also their profits. It is the content of the article and not the defendant's motive or primary motive to increase circulation which determines whether it is a newsworthy item as opposed to a trade usage under civil rights law. It is settled that a picture illustrating an article on a matter of public interest is not considered used for the purposes of trade or advertising within the prohibition of the statute, unless it has no real relationship to the article or unless the article is an advertisement in disguise. A contrary rule would unreasonably and unrealistically limit the exception to nonprofit or purely altruistic organizations which are not the only or even primary source of information concerning newsworthy events and matters of public interest. So the plaintiff goes on to assert that this picture was used for advertisements, and this is a hidden ad, a secret ad. This column is an advertisement. The facts on which the plaintiff relies are entirely circumstantial. Sound familiar, Maddox? He does not claim to have personal knowledge or direct proof that this particular article was actually published by the defendant for advertisement purposes. Circumstances on which he bases his claim are the fact that the news column contains information normally included in an advertisement, and the fact that some or all of the stores mentioned in the article had previously advertised products in the magazine. You got to show a contract, an agreement, a statement, something to show that this is an ad. In this case, in your case, it's worse because you're alleging that Dick's Twitter is an ad, that his show is an ad for the show. That's not a thing, by the way. Like, the show can't be an ad for itself. An ad in disguise, as they're talking about here, would be if Nike paid someone to write a story, a news article about people who just love the new Air Jordans. Do they still make Air Jordans? Air Kobe? Kobe, like you jump over people and it rapes them or something? That's rude. I'm sorry, Kobe. I don't know. Like, they have to, like, a company has to purchase an ad and try to disguise it as a news article. And by the way, this happens all the time. Just open your paper and suddenly you're learning about stuff that you didn't think anyone cared about because someone paid to have an article shoved in there. So the question is not whether this information might be part of an advertisement somewhere or could be construed as an advertisement. The question is whether the article or podcast is of legitimate interest to a consumer. A podcast about you is of interest to anyone who's ever heard of you and people who haven't heard of you because you're an e-celeb. So you get less protection. You can't just claim that I can't stress enough how much this has to be an ad. Applying these cases to what you've alleged, the only thing that even comes close to an ad is the Facebook ad that Dick purchased. You're not mentioned in it. You're not referenced in it. Your podcast isn't mentioned in it. Your trade names aren't mentioned in it. None of that happened. The fact that Dick might mention you on his show, or release tons of hot goss about you on his show, or say something mean about your girlfriend in a tweet, or whatever, those aren't ads. Those are content. And content, really hard to show it as not newsworthy content unless you have evidence that it's not. And evidence that it's not content is typically a contract. A promise from someone to the person doing the broadcast or column that, hey, you do this, I will pay you directly. Not, I'm trying to get fans. That's not the advertisement they're talking about. It can be, right? Like if Playboy, for example, grabbed, I don't know, Emma Watson's face and slapped it on the front of their magazine without her consent, hoping that a bunch of people would want to see Emma Watson naked and would buy the magazine, and then flip frantically through the pages while they've got their Harry Potter books open. I don't know. Whatever they do. That would be the unauthorized use for advertisement. Maybe it would. Maybe it would. I guess more appropriately would be as if Playboy put out an ad with Emma Watson's face on it. Like an ad on Facebook, right? We'll use that example. So Playboy wants to go ahead and target Maddox fans. And so they, I was gonna make a pedophilia joke just because I'm trying to be rude and provocative, but I'm not. That's mean. I don't want to kick you while you're down. So let's say Playboy takes out an ad for Maddox fans, puts Emma Watson's face on the ad, and says, "Check out issue 98, Playboy, Playboy.com," without her consent. That if they could show that this happened in New York, that someone in New York got this advertisement, that would be under the statute, because that would be an ad, strictly an ad for commercial purposes, and strictly using a person's face strictly for the commercial purpose. Like, it's not just that it's an ad that's strictly for commercial purposes, but the use of the image has to be strictly for commercial purposes. But if they were writing an article about Emma Watson and maybe like her brave foray into feminism and her speaking engagements, like, and they put her face on the thing, like they might get backlash, right? But when people go and then they read an article about Emma Watson and pictures of her in public speaking on a podium, like that probably wouldn't be an ad, because it'd be a matter of public concern. People want to know about Emma Watson for some reason. I don't know. Anyway, we've gone through these documents. We've gone through them so many times. The sad thing is there are apostrophes that I have missed every single time I read it. Every time I look through this document, I learn about another apostrophe. And in this case, today especially, man, the commas are not good. But here's what you do, buddy. Here's how you write this. This is not legal advice. I can't advise you. You should take the attorney that you hired to sign this thing and talk to him for a little bit, right? Like, that would be and he would have told you not to file this. I can only assume that any ethical attorney would have said, you really shouldn't file this because this is a bunch of nonsense and you got nothing. But whatever. You should talk to him. Because if you're drafting a cause of action, you need to lay out the elements, the statutory elements of the crime. So you put the statute in the cause of action. Then you lay out the elements and cite the case. Then you show how each element of the case is violated by the actions of the defendant. This is how you build a case. This is how you make an argument. You can't just say a bunch of nonsense and expect a judge to believe you, because you have 20 million vested reasons as to why a judge should be skeptical of your claims. You should say, you know what? Okay, prove it. This was your chance to do it, and you didn't even come close. You didn't show the elements. You didn't show any working knowledge of the law. You didn't. Another thing you can do in your cause of action statement or your analysis statement, whatever you want to call it, you have a chance to head off contra arguments, and that's important, because the contra argument of all this is he didn't show a single damn thing that's an advertisement. Not one thing. Nothing. That's the contra argument. So then you have to go through and say, they're going to say these weren't ads, but they are ads for this reason and this reason and this reason. You have a hard, an uphill climb there because what you haven't shown ads, and you haven't shown any reason that these would be ads. So, I mean, that's a huge uphill battle for you. But, you know, I mean, you've failed really hard here. So I don't know. Anyway, I hope you guys kind of find these delves into the law, into the cause of action, what the courts have said about it, what they're going to look at, man. Because that's, if you're ever suing someone, you got to know what the courts have looked at in the past and what they're going to look at when your stupid case comes across a clerk's desk. And like Maddox, you've published books, man. The clerk is the junior intern editor to you who reads 50 manuscripts an hour, and they skim the first 2 pages and they say, this is trash. If you don't catch them on the first page, it's trash, right? Clerks have to read through the whole thing, but they read this crap all the time. When you make a 53-page document repeating the same language and showing no actual allegations or evidence, you're not winning the clerk. You got to win the audience, man. The court, inside baseball, court, law, the practice of law is knowing your audience, who it is, what they're after, what they care about. And that changes as it goes. In this first filing, your audience is the clerk, because the judge isn't going to just, eventually a judge will probably read through this. What they're going to want the clerk to do is really read through it and summarize. They're going to want to summarize main points, main arguments, main objectives. You want to win the clerk. You want to win the guy who's been reading 100 stupid cases like this. And you want to catch his attention with some, and this isn't salacious, right? Like, you don't want to be you use lots of fruity language and flowery language that isn't helping you at all. You want to novelly and interestingly tie facts to law. And I know that sounds weird, but we're nerds. Lawyers are nerds. Clerks are lawyers or lawyers in training, and they're nerds too. And they want to find out how your cool case looks like this other case when one's about a podcast and one's about a magazine. And if you don't do that and you don't catch their attention, the point is missed. If you don't provide evidence for how these elements take place, and make it easy, man, because if the clerk has to go and say, God, what the frick? What are the 4 elements of this cause of action? I don't know. I gotta go research this. I gotta find this. I have to find out how the court has ruled. You lose your audience immediately. Then as you get to court, right, your audience shifts to a judge and eventually to a jury. And all of these people are looking for different answers. Prior to court, your audience is the other attorney. You got to get the other attorney engaged. You have to convince this person who is paid to hate you to agree with you and your client. Like, this is the law game. The law is communication. It's persuasion. It's compromise at times. It is strategic retreats from various points or arguments. And importantly, it's prediction and analysis. Not of the law. Yes, analysis of the law, hugely important. You should have done a lot of it. But it's analysis of your audience and what their desires and goals are from these encounters and interactions and discussions. And if you can't do that, and if you don't understand that, hire someone who can, for the love of God. That's what we do. It's what we do. You yell into a microphone for a bunch of people, and you say whatever you want, and then the few people that agree to you come and listen, and that's great. You've done an okay job of that over the past 20 years. I think you've made some poor business decisions, but like overall your content is fine. You're appealing to certain people. You end up knowing your audience and knowing what they want, and that's great. But your audience, right, in theory, is the whole earth, and you're attracting a percentage of them. When you get into law, You get into law and argument, your audience is much smaller and has specific tailored interests that you need to figure out sometimes. Because if you're in a negotiation, you have to know what's valuable to them that's not valuable to you, right? Because you can give them that stuff. Give it to them. Here, some statements giving and conceding that some of Dick's actions have nothing to do with you would have gone miles beyond the allegation that his sole purpose in life is to ruin you, when the overwhelming majority of his episodes and the overwhelming majority of the time in those episodes is not dedicated to you. That's just conceded, buddy. But anyway, yeah, so I hope you guys find this stuff interesting, these deep dives into law. We've got more coming. And of course, once the defense documents drop, I will be all over them. We will be analyzing them. And we will probably be laughing pretty hard at the hill that Maddox chooses to die on. I don't want to even want to say faces, because I assume that the legal teams of Dick, Patreon, and Weber Shandwick are going to be a lot more than random Michigan lawyer who happens to have a New York license. I mean, the Patreon lawyers themselves look like pretty heavy hitters. I don't know anything about New York lawyers. I don't know anything about Minnesota lawyers. I don't care who's opposed to me, right? Like, I know my position and we fight for it. But I will tell you that a brief look at resumes, Patreon's lawyers are wildly qualified. We don't know who Dick's lawyers are, but the indications about who they may be sound like they're wildly qualified too. We have no idea who Weber Shandwick. I assume Weber Shandwick has in-house counsel because they're big. And we know they have in-house counsel, right? He's a named defendant. By the way, like, he has probably dealt with this a lot more than Maddox's attorney, and that'll be interesting. It'll be interesting to see what happens with that stuff. So anyway, thank you guys for watching these hour-long videos on the lawsuit. More are coming, like winter in Game of Thrones, except sooner. So see you guys around.